by the gift or any other lawful means. Uh, what I can say is that there are so many rights included in the copyright itself, especially in the field of a song, where there and also the what we call the rights that can be performed. It's like movie also. There are related rights there, where the rights also being owned by other party other than author itself. For example, if you are saying about the song, Chris Dayanti song, what we call now, menghitung hari perhaps. Um, the song itself, who wrote that, who made this song has their rights, and then Chris Dayanti as the singer has their own her own rights also. And when there are it is published in the cassette or any other means, the publisher also has the rights. So that's what we call the related rights. The important note is that the protection of copyright is automatically. So, the protection will will be born. The protection will automatically embedded to the work after it is being published in a tangible form. And it is actually doesn't need a recordation, or we call registration of a copyright. So basically, the right already embedded without the recordation. So after it is being formed in a tangible work, it is protected. But the problem is, even though we do not require the recordation, when there is dispute, especially in Indonesian court, our judges always ask for the written evidence. This is to fulfill the provision regarding the evidence that they need at least two kind of evidence, and one of them is the document. So sadly, I would say that even though copyright is not required to be recorded, for safety reason, it is recommendable to always record or register your copyright. And the third important note is that the duration of the protection of a copyright is as long as the author is alive. So, for example, if I make a song, the protection of my song will be until my death plus 70 years after my death. So if I die today, then yeah, the song will be still protected until 2092. If I die today, hopefully I'm not dead today. And there is also important note if the copyright is owned by a legal entity. We need to transfer the right from the real author to the company and so on. Okay. And we will also need to learn about the moral rights and economic right. So in a work, we say ciptaan. In a work, there is actually two rights embedded in the subject. Let's say a painting of Mona Lisa is actually has two rights embedded there. The first one is moral rights and also the economic simple thing about moral rights is that the author, let's say the painter, has the right to always be included, his name, I mean, to be included whenever the work is being published. So if I'm writing a song, I have to write that my name is always being included in that song. The other thing is the economic rights. The economic right is where you can, we call, uh, explore the financial side of the work itself. Um, you may know that there was a dispute between the author of a song that is sang by, that is covered by Triswaka. At that time, the moral rights perhaps already covered because the YouTube of Triswaka already mentioned the name of the author. But perhaps the problem raised because of the economic rights. In this case, if you have the YouTube account and it can be monetized, there is a financial traffic there. Trisloka can get the monetized from YouTube, and that part is not being shared to the real author. So that's why the problem raised. I think that's to simplify how to differentiate moral rights and economic rights. In terms of dispute resolution, well, I would say dispute, even though in the IP laws, including copyrights, there are actually several law jurisdiction there. Let me say this way. In a copyright, other than civil rights, the ownership rights, the civil rights, the law itself already mentioned about the criminal proceeding that can be taken by the IP owner against the unlawful use from other party. So that's the complexity of the IP law actually. So when we say dispute, it is not only about the civil dispute, but there is also an intersection with the criminal things. Okay, for the civil lawsuit, the laws already provided the rights to file the cancellation of recordation. So it means that if you record something, if you have the certificate of copyright, but it is actually not your rights, or if you fake the information of the, you provide the fake information during the process of the recordation, then it can be recorded, cancelled. I mean, let's say if I deliberately request the recordation of a song made by, that actually made by Belly Guslow perhaps. You know lagu Bunda, and then I asked the IP directorate to issue a certificate of Bunda under my name, then it can be a subject of cancellation of recordation. Other than that, the civil lawsuit also available if you want to request the let's say the compensation from uh, copyright infringement. So wait, let me close my door first. Actually, I'm at my home and there is a family gathering. It's getting crowd.
You know,
Sorry, sorry. Uh, okay. We are talking about the infringement lawsuit. So when there is a lawsuit, when there is an infringement, the copyright owner has the right to file a lawsuit with the commercial court asking for the compensation. So the process is actually a civil lawsuit, but it is based on the infringement of or violation of the rights. Let's go back to the Triswata things. If the author of the song covered by Triswata is still objecting the use of the song, the cover song, he can request, he can file the lawsuit and request Triswata to pay some amount of money based on the financial loss. So that's what we call the copyright infringement lawsuit. Mm, Other than that, there is a criminal provision. It is actually a simple, the simple, what we call the simple explanation for this is that uh, when you ask the let's say you may know that there are several CD, compact CD or DVD, pirate DVD, and it was being raided by the police. I think there it is the simplest example. Uh, I don't know whether you all of the students here are aware that in early 2000s there was a raid by Microsoft against several industries that is using the unlicensed software of MS Words. There is where the criminal provisions is used. Other than that, to resolve the dispute, we can use the provisional injunction. So, provisional injunction is simply like a putusan sela, but this is a little bit different because you ask the court to hold on something, but with the payment of money. I don't have the exact example for this, but actually, the movie for Sukarno, you may recall in 2012 or so, there was a dispute between Rahmawati Soekarno Putri against Hanung Bramantio, something the director of the movie Sukarno, where Rahmawati believed that the movie was not mirroring Sukarno so well. That's why she asked for the injunction. So she asked the court to stop the display of Sukarno at several movie theaters. And the last one to resolve the dispute is by alternative dispute resolution. And one of them is by filing the arbitration as we are going to discuss today. Um, well, let's say this one. Other than the previous option, you know that in the Article 95 of the copyright law, in addition to the infringement and infringement proceeding by uh, the law, when we filed a case either in the state police or with the investigation directorate in the IP office, the officers are obliged to request the mediation before the proceeding of the penal charge. So let's say after the rate of infringed product, let's say someone in Tanah Abang is being the, the 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 products there is being taken by the police because he is believed as the infringer of a copyright, even if after the products are being suspended by the police, there is still a mediation proceeding to be processed to make the peace settlement between the copyright owner as well as the allegedly uh, infringer. So this is the example of the case where involving the cancellation lawsuit. This is about the PSMS Medan. You may read the case number 2. It was held in 2019. This is also only an example. You can read by yourself. Well, you may see the logo PSMS Medan. If I'm not mistaken, should be the plaintiff Mahiono is he claimed himself as the author, and PSMS Medan is using his logo without any rights. So that's why he is filing the cancellation of the registration. So the verdict is that the plaintiff is granted. So the recordation certificate is being cancelled. This is readable. And then this is also the example of infringement lawsuit. You know, this boy is the one who was very obese and then being trained by Aderai. So actually there is a lawsuit about the portrait where Jeffrey Tarigan's photo is actually being used by Tribune for so many times of news. So Jeffrey believed that the use of his photograph by Tribune is not rightful. So that's why he's filing the cancellation, the infringement lawsuit. And then this is also the provisional injunction, which I already mentioned. Okay. This is just, we can skip this. But this is the criminal things. Again, in the IP matters, we can still also, we need to prove whether there is a mistake or also if the case was unlawfully and so on. Well, this is the case of copyright infringement as well. You see the song lagi cantik, perhaps you know that is used by someone for the door. So whenever you press the door, the song will the door will sing something lagi cantik, but it is actually not permitted by Nagaswara. So that's why Nagaswara filed the lawsuit. This case settled by mediation. So after the product is being weighed, and then the police they requested the mediation and it's done there. The Asian region, the Southeast Asian. Uh, well, the definition is more or less the same, but the protection, the term of protection is different in each country. So even if I, an Indonesian, infringing a copyright in Singapore, the law will be different from in Indonesia. So it will be territorially. I don't think it's a word, but it depends on the land. It depends on the country. So the dispute, the case will settle based on the location itself. So for the Singapore, for literal, dramatic, and so on, it will last for 70 years after the author's death. So quite the same. It's also for the sound recording and film. And for the broadcast, copyright lasts for 50 years. I think it's quite more or less the same with Indonesia. The different thing is for Thailand, because Thailand, the copyright terms is only plus 50 years after the author's death. So there is a 20 years differences. In the Vietnam, the duration will be different from the cinematographic and photographic works. So it is for 75 years from the date of the first publication, or 100 years from the date of the fixation. So they have a different way to count the duration of a copyright. And then for Cambodia, it is same with Malaysia for the author's lifetime plus 50 years after the death. For the anonymous, it will be 75 years from the date of publication, and so on. So for Laos and Myanmar, the duration is also 50 years. So it's actually in Indonesia is quite longer. For the copyright disputes, we are talking about alternative dispute resolution. In the Thailand has adopted the alternative dispute resolution since 1987. But for this kind of resolution, they have the online platform called TalkDD. So one of the parties make an account into TalkDD and then fill the related, and then later on the app will meet both parties for an online meeting. So unfortunately, the usage of the TalkDD is still limited to the Thailand language. And therefore, Cambodia, there is also the provision to allow both parties to resolve this matter using the alternative dispute resolution. So that's the same. Allow or also allow the parties to enter into dispute alternative dispute settlement. whether through reconciliation, mediation, or administrative remedies. And such alternative dispute resolution is also known in Myanmar as well as in the Vietnam. So the next slides will discuss a brief about arbitration. Well, actually, this is not quite of my field, but I can give you a bit of, I can share you a bit of the arbitration. Like I said before, normally IP dispute in Indonesia is not being settled by arbitration. It is, I don't know whether it is uncommon or what, but perhaps just because the arbitration proceeding is not relatively known by the parties in Indonesia. So when we are talking about the arbitration, it should be according to the Article 1 of Law Number 30, 1999 about arbitration. So here's the problem with the Indonesian arbitration law, that if we want to settle the case with the arbitration, it should be based on an agreement. So the parties must mention that the dispute in the future needs to be settled by the arbitrary proceeding. If the agreement doesn't mention that kind of wording, we do not think that the arbitration can be proceeded. But you can make a separated arbitration agreement after the dispute has occurred. So basically, we still can do that, but mostly based on the agreement in the very first time. This is the notice of arbitration. It must contain the name of address, and then the reference, the agreement or issue, and then the grounds, and the desired method of settlement, and so on. And the Article 66, letter B, is mentioned that the IP, intellectual property rights, can be settled by arbitration as well, other than the commercial, the banking, financial, capital investment, and industrial. The examination will be held within maximum of 180 days after the arbitral tribunal is formed, and then it can be extended by the following reasons. And if in the court we know that the judges will make a decision in the arbitration proceeding, the name is award, so the arbitral award must be issued within 30 days after the examination is concluded, and it should be final and binding to the parties. So there is no legal remedies, no appeal, no cassation, no judicial action, review, and so on. And the problem with Indonesia, sometimes the losing party filed a lawsuit even though the arbitration has already issued the award. That's another issue in Indonesia. Okay. This is the foreign arbitral award. So in Indonesia, as you know, you may know, perhaps in Indonesia we have the Singapore, and then for the IP, we can actually file arbitration through the WIPO, the World Intellectual Property Organization. The decision is still, sorry, not the decision, the award is still applicable in Indonesia, even though it is issued by foreign arbitral as long as it is given by an arbitrator or tribunal in a state that is along with Indonesia, uh, Indonesia is a party or to a bilateral or multilateral treaty that recognize the foreign arbitral court. So let's say if we are going to settle a case under the Singapore arbitration, Indonesia must be part of the bilateral treaty with the Singapore. But I believe we are. Or if we are going to settle the case with the WIPO, as uh, we already ratified the TRIPS agreement and so on, so we are part of multilateral treaty. We can have the WIPO award to be enforced in Indonesia. And we also have to note that the award cannot be contravened with the public order. And before it is being applied or it is applicable in Indonesia, we need to have the award to be to receive. So this is the institutions. Sorry, I forgot to mention about BAMHAKI here, but actually there is here. But the problem is there is no case handled by BAMHAKI today, so unfortunately there is no example I can give to you on how to settle the dispute with the arbitrary cause. But actually, in outside of Indonesia, there is a case involving Netflix where Netflix didn't pay the royalty of a movie. So it was settled by the arbitrary there and already given the award. So I think that's all for my part, Pak Prananda. I give it back to you.
Okay, thank you, Mr. Romali, for your insightful and wonderful presentation. It will be beneficial for our participant. Yeah. It is a very informative lecture from you. I note several important point from your presentation. The first one is, as I know, copyright content of two rights, is economic and moral rights. Yeah, that the creator an authority to replace or if we're talking about economic right, it is related with publication, and then there is also any dispute resolution mechanism to accommodate IPR dispute, yeah, through BAMHAKI in Indonesia. But unfortunately, based on your experience in here, it is very rare verdict that illustrated or reporting regarding copyright issue in Indonesia. And then regarding the duration copyright in several countries in ASEAN, yeah, it depends by legal political that adopted by the government, especially regarding how long the duration of protection and etc. And then lastly, if I do not mistaken, IPR dispute also being accommodated to resolve in arbitration. Yeah. Indonesia, as you said before, also engaged in WIPO, multilateral treaty, and then if WIPO issue an award about IPR care, as it is not a contrast with the execution need to get approval from Central Jakarta District Court. Yeah.
Yes.
I think that's all the point that I can resume from your presentation. Now we will go to a Q&A session. Dear participant, if you have any concern or question to our notable speaker, please raise hand and go ahead to uh, deliver your question to our notable speaker. Is there any question from the participant?
Uh, you can also ask about internship program if you want.
Yes. Is there anybody who interests asking about internship program or about the topic of our discussion today? Yes, sir. Please stand up and go to the central. Yeah. What's your name, sir? Please stand up here. Okay.
All right. Thank you. Let me introduce myself. My name is Brian Roy. I am college student from Faculty of Law, University of Law in fifth semester. And I want to ask my